The law of tort. Causation. Causation must be established in all torts where damage is an element of the cause of action. To demonstrate causation, the claimant must establish that the loss they have suffered resulted from the defendant's act or omission. In most cases, a simple application of the but for test will resolve the question of causation in tort law. That is, but for the defendant's actions, would the claimant have suffered the loss? If yes, the defendant is not liable. If no, the defendant is liable. This test can be seen in the case of Barnett v. Chelsea and Kensington Hospital, where the claimant went to hospital complaining of severe stomach pains. The hospital turned him away and told him to contact his GP in the morning. He then died of arsenic poisoning. The hospital was not liable, as even if they had correctly diagnosed him, there was nothing they could do to save him. So, but for their actions, he would have died in any event. Causation may be problematic where there exists more than one possible cause. Various formulations have evolved to ease the burden of proving causation in such situations. Where there exist two causes occurring in succession, it may be possible to identify the factual cause of the damage. In Performance Cars Limited versus Abraham, the first defendant crashed into the claimant's car. This caused the car some damage, requiring a respray. Before the car was resprayed, the second defendant also crashed into the claimant's car. On a simple application of the but for test, only the first defendant was required to pay. However, at times policy factors may come into play. In Baker v. Willoughby, the defendant injured the claimant's leg. Before the claim was settled, the claimant was shot in the injured leg and had to have it amputated. The defendant argued they were only required to pay damages for loss of earnings until the shooting. The court, however, stated they were liable to continue to pay even after the shooting. Conversely, in Jobling v. Associated Dairies, the defendant was not required to pay for loss of earnings after the onset of the back condition, as the defendant's breach could not be said to cause such losses. Where there exist two or more causes which operate concurrently, it may be factually impossible to determine which one was the cause. This has proved problematic, not least because it is the claimant's responsibility to establish which one was the cause. On general principles, the burden of proving this is on the balance of probabilities. This means the claimant has to demonstrate that there is at least a 51% likelihood of the cause being the breach of duty of the defendant. Where there are two causes, the burden of proof is impossible to discharge, as it is a 50-50 chance of each one being the cause. Such an approach would leave the claimant uncompensated, often for an obvious breach of duty. Various legal formulations have arisen to circumvent the approach. In Bonington Castings Limited versus Wardlaw, the defendant was liable as the breach of duty in failing to provide an extractor fan had made a material contribution to the claimant's lung disease. In McGee v. National Coal Board, the defendant's breach of duty in not providing showering facilities had materially increased the risk of him contracting dermatitis whilst cycling home covered in brick dust. The House of Lords held these were sufficient to establish causation. A novel approach was taken in Fitzgerald v. Lane. The claimant was struck by two cars when using a Pelican crossing. He suffered tetraplegia. He was unable to determine which car had caused his paralysis. The Court of Appeal reversed the burden of proof and stated it was up to the defendants to show they did not cause it. If they could not do so, they would both be jointly liable. However, this approach was overruled in Wilshire v. Essex. A junior doctor had given a premature baby too much oxygen. The baby was blind. There were 5 possible causes of the blindness, with only one of them being the excess oxygen. The claimant sought to rely on Fitzgerald v. Lane, so that the doctor would have to prove their action was not the cause. The House of Lords, however, held that the burden of proof remains on the claimant. Where there is an intervening act, this may break the chain of causation, removing liability from the defendant. This is known as a novus actus interveniens. The legal test applicable to determine if the chain of causation is broken depends upon whether the new act was that of a third party or an act of the claimant. Where the new act is of a third party, the test is whether the act was foreseeable. If the act of the third party was foreseeable, the defendant remains liable and the chain of causation remains intact. If the act of a third party is not foreseeable, this will break the chain of causation and the defendant is not liable. In Home Office v Dorset Yacht, the actions of the young offenders in stealing the boats was foreseeable, so the Home Office was liable. Whereas in Lamb v Camden, the court held it was not foreseeable that squatters would move into an empty property. This suggests a high degree of foresight is required. Where the act of the third party is negligent, this is more likely to break the chain of causation. In Knightley v Johns, the negligent action of the police officer in directing the claimant to drive through a tunnel on the wrong side of the road broke the chain of causation. Where the new intervening act is that of the claimant, the test is whether the claimant acted reasonably in the circumstances. If the claimant's actions are deemed reasonable, the chain of causation remains intact and the defendant is liable for the actions of the claimant. If, however, the claimant's actions are unreasonable in the circumstances, the chain of causation is broken and the defendant is not liable for the actions of the claimant. In McHugh v Holland, the claimant's action of jumping down steps with an injured leg was deemed unreasonable. In contrast, a doctor's actions in Baker v T Hopkins & Son Limited in going down a well with dangerous levels of carbon monoxide was not considered unreasonable, as he was attempting to save lives. In summary, causation is generally decided by the but-for test. However, if there are multiple causes, a more flexible approach is applied. Where there is an intervening action, the courts need to determine if the chain of causation has been broken. This depends on whether it is the act of the claimant or the act of a third party. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.